Thank you, Your Honor. Before you today on State versus Justin Ruth, we're here today for sentencing. The state of Ohio has had the opportunity to review the pre-sentence report and is prepared to go forward. And I would remind the court that we have an agreed 2-year prison sentence as part of the plea agreement.
So, Your Honor, we do have an agreed 2-year recommendation for prison for Mr. Ruth. Mr. Ruth prior has done treatment. He did treatment at Wellbrook Recovery. He indicated he was sober for a year. Once these charges came to, he did become stressed. He did relapse a couple of times, so that is the reason for testing positive for the methamphetamine. With regard to the controlled buys, Mr. Ruth indicated that he was buying the drugs and selling them to feed his own addiction. He indicated he would purchase extra drugs, sell the remainder, and keep some for himself just to keep his addiction going. Your Honor, he does have a good support system. He is married. He does have children. His one child is 7 years old and does have special needs. He does try to be there for him as much as he can. So we just ask the court for any leniency today. Thank you.
I would benefit more from treatment than prison. I don't think I should not have consequences, but
treatment for what?
Buckle up, guys. Today we're stepping into a courtroom where what seems like a routine sentencing quickly starts raising serious questions. The defendant hopes the judge will choose treatment over prison, while his attorney highlights addiction, family responsibilities, and efforts at recovery. At first glance, it sounds like a plea for another chance, but the judge isn't showing much emotion. You can already sense that every word spoken from this point forward will determine whether this man walks away with hope or faces much harsher consequences.
For the addiction, sir.
Well, you told Miss Warren that the last time you used meth was in March of 25, and you tested positive in April of 16, so how is that possible?
When we were talking about active addiction, that was a year ago.
What does active addiction mean?
The active addiction is when I was using regularly. I did relapse recently due to some stress, but I was able to put it back down. And
you tested positive when you were referred for a PSR on April 22nd. When that was addressed with Miss Warren, you indicated you don't know how that could be possible because you hadn't used since March of 2025. Why did you tell her that? Did you use, or do you not know how you tested positive?
I had used, Your Honor.
Why did you tell her you didn't? That you had no idea how the positive test would have happened because you weren't using it?
Because honestly, I thought I had quit.
What do you mean you thought?
Well, I had quit long enough that I should have had a clean test.
So you lied to her. When you told her you hadn't used since March of 2025 and you tested positive on April 22nd of 26, and you told her you had no idea how that happened because you hadn't used for some 13 months, you lied to her. Right?
Yes.
I don't, you got some equivocation on that?
I wasn't actively using.
I don't know what that means. If you use, then you're active. Then you're actively
I had used and thought I would have been clean.
Why are you trying to split hairs like this?
I was just being.
See,
sir.
Now let's get to the next part of this thing. Written version. When you went over for your referral,
the judge immediately shifts the focus toward the defendant's recent drug test, and this is where the conversation becomes uncomfortable. As questions become more direct, the defendant struggles to keep his explanation consistent. He first denies recent drug use, then slowly changes his story until he finally admits he wasn't truthful. The judge notices every contradiction, making it clear that honesty matters just as much as the crime itself. This exchange begins to damage the defendant's credibility in a major way.
You said you were asked to get drugs from an individual you knew, and you wanted enough for yourself. When you talked to her, when she interviewed you when you came back, you indicated that the drugs, a large amount of drugs found in your bedroom where you stayed at this house, were not yours. But you decided you did things illegal in the past. You had been on drugs, but the drugs weren't yours.
What I meant by
So
that,
if the drugs weren't yours, it resulted in the felony 2 charge. Why did you plead guilty to this case?
because I had drugs, and I was holding myself accountable for the drugs that I
So
had
you
in there.
didn't, these drugs weren't yours.
Those particular ones at that time,
In your bedroom weren't yours?
at that particular time, no.
Okay, whose were they?
There were 3 other active users in the house.
Active mean using.
Yes, sir.
Stop with the active and inactive. What's an inactive user? There's no such thing.
Correct.
Okay. So you pled guilty to an F3, which there's a presumption for prison. You know that, right? Because we talked about that.
Yes, sir.
Okay. But the drugs weren't yours
Correct. At that time. But I had some.
at that
so
time. That's what I'm talking about. The drugs found. They could only have been found at that time. Those weren't yours. So how am I supposed to sentence somebody for a crime that they say they committed that they actually didn't commit? How am I supposed to do that?
Because I had committed that crime.
But you're not charged with, in the past, committing that crime. You're charged with, in this situation, committing that crime. Well, of course, the real answer is you're lying to me, okay? Because you lied to her. You're lying all over the place. Okay, so that's the real answer. Those drugs were yours, okay? You were living at the house at that time, right?
I wasn't staying at the
What?
time. I was not staying at the house at that time.
You were staying versus living. We're gonna parse this definition now too. Where were you staying?
Most of the time I was staying at my wife's house.
Okay, and didn't you say somewhere along the line that you were in treatment at that time, so you weren't staying, living, whatever at that house?
I was preparing to go to treatment, and then
Well, didn't you
I
say you
finally
were
got
in
in like a
treatment?
week later.
Didn't you say you were in treatment at the time, as opposed to preparing to go into treatment at the time?
I got into treatment maybe a week later.
Right.
Is when I finally got in.
But did you tell Miss Warren that you were in treatment at the time?
I told her that I completed treatment shortly after.
Okay. Whew. So you started this by saying you want me to put you on probation, right? Is that right?
Now, the judge turns to the drugs discovered inside the bedroom connected to the defendant. Instead of accepting responsibility, the defendant insists the drugs belong to someone else while still maintaining his guilty plea. That explanation only creates even more confusion. The judge repeatedly points out how the story doesn't make logical sense and openly accuses him of being dishonest. With every answer, the defendant sinks deeper into trouble, making the courtroom atmosphere noticeably more tense.
At some kind of treatment, I think I would benefit from, yes.
Okay.
Further treatment.
Well, I thought you already had treatment.
I had some.
Okay. I mean, at best, this was kind of a half-assed treatment, wasn't it? Wasn't some of this on the computer?
I did a residential, and then was doing some online meetings and stuff. And
What do you do on an online meeting?
it's basically the same as in person. It's just over.
Well, it's nothing like in person. Okay.
The format is.
It's a format. Well, it's a complete waste of time. So the treatment you're talking about that you completed was Wellbrook Recovery?
Yes, sir.
You went in there on March 23rd, right?
That sounds about right. Yes.
That's what the records show. And the offense here was committed March 18th. So when you said you were in treatment and you weren't at the house and it wasn't yours, that's not true. Are these records we have, or are these Mr. Ruth saying this?
They're records from the actual facility, Your Honor.
Okay, so May 6th is completed. And then you reported, which means this is you talking, that you would attend alumni sessions. What's an alumni session?
Alumni sessions are people that have graduated, from that program, become alumni, and twice a week they would have AA meetings, NA meetings.
And so you went twice a week
Yes, sir.
until this happened?
I probably stopped going to them, 3-4 months maybe, before this event happened.
When did you get involved again with the meth after you had stopped using after Wellbrook Wellbrook Recovery?
When I got arrested for this and everything was going on, I got pretty stressed out. And
When did you get arrested for this?
Your Honor, I believe it was beginning of March of 2026.
And so by your story that you're telling today, you had been not using drugs for a year. You get arrested and you start using drugs again. Is that right?
That's correct.
Okay. And where did you get the drugs when you started using again?
Tension now shifts toward treatment, probation, and the defendant's recovery journey. While he argues that rehabilitation would benefit him more than prison, the judge carefully compares his statements with official treatment records. As the timeline of events is examined, several details fail to line up with what the defendant previously claimed. Instead of strengthening his request for leniency, this discussion raises even more doubts, leaving the judge increasingly skeptical about everything being said.
I couldn't tell you the gentleman's name. I found him online.
How did you find him online?
It's
What website did you go to say, where do I find a meth dealer in my area? Where?
it was an app called Grindr.
Grindr?
Mm-hmm.
Isn't that some kind of sex app or something?
It is, but I found that it's also full of people who...
So where did you find these drugs then, on the Grindr app?
Someone that was advertising that he had drugs.
Who was advertising that?
The gentleman that I found online on that app.
I know who.
I couldn't tell you his name. I've never seen him before or after.
So where'd you meet him?
At the Headlands Beach.
And how did you know who it was? How did you find this person?
He said I'd be in a red car, and I told him I was in a black car, and he came and gave me the drugs. I gave him the money, and...
Okay, so you only used once then?
Twice.
Twice?
It was the same batch of drugs, but I used, yeah.
Okay, so you only bought drugs once?
Correct.
Okay, what quantity did you buy?
A gram.
A gram. When you were using the year previous, for whatever period of time that was, how much were you using a day?
Probably 2 to 3 grams a day.
Okay, so you bought a gram from somebody that you met on some app that you connected with somewhere, bought a gram. How much was a gram?
$20, sir.
Okay, and so you used some of it, right?
Mm-hmm.
When did you use the rest of it?
I want to say it was April, somewhere around the...
So you saved some of that gram for a month.
I had thought I'd thrown it out and then found it again
Where'd you find it?
in my room near the trash can.
Okay. Boy, oh boy. That would be unusual that a meth addict would buy a gram of meth, not use all of it,
I thought I had, to be honest.
and then threw the rest away.
But thought I had used all of it, thrown the bag away, and then when I found the bag, it still had some in it, and I used again.
Okay. Other than that, you didn't use it all between March and April when you got arrested.
Correct.
Okay. Don't believe that. I don't believe that. So far, you've told me nothing that I can reliably believe. Who's Stephen 6?
This is easily one of the most surprising moments in the entire hearing. When the judge asks whether the defendant found meth after relapsing, the answer catches everyone off guard. He admits using the Grindr app to locate a dealer before describing how the purchase happened. The judge carefully questions every detail of the story and quickly points out how unlikely it sounds. By the end of this exchange, it's obvious the judge has almost completely lost confidence in the defendant's version of events.
That would be my roommate, the owner of the house that I was staying in.
How did you meet Stephen 6?
Honestly, I don't remember. He was a neighbor. I lived, prior to being at that house, I lived pretty close
How did you meet 6? Through drugs?
Probably, Your Honor.
Well, so your story is that on these drug sales, or 6's story on these drug sales, is that he was acting on your behalf on the 3rd sale. Is that true?
I mean, he had his drugs, and that's where I got them most of the time. He supplied a
Well,
lot of them.
the CI is the one that got you involved in this, right?
Yeah.
Somebody you knew, right?
That I met through 6, yes.
Okay. And on the 3rd controlled buy on March 10th of 2025, the CI set up another buy with you, right?
Probably.
Come on.
I mean, I can't.
I mean, I
recall
never saw
exactly.
anybody, you're like Bill Clinton out there, hedging every word, okay? So you agreed to sell this CI some drugs on March 10th, and you weren't at the residence, right?
Sounds correct, yes.
Okay,
I would have had to gotten the drugs from 6
okay.
to give to him anyways, so I just told him to skip me as the middleman that particular time, and
So who's the middleman, you or 6?
I was.
Okay. Which is why all those drugs in your room didn't belong to you, right?
Correct.
Okay.
There was an extra gentleman that had been staying there for a while that didn't actually live there, didn't have his own space. So since I wasn't using the space, he was pretty much using my room.
Wasn't this a 3-bedroom house?
Yes.
Okay. At some point, you've got to become acquainted with the truth. You ain't anywhere near the truth now. And so my guess is when you're done with your sentence, you'd be right back doing the same thing again.
I don't believe so, sir.
Yeah, I think so. But that remains to be seen. That's up to you. Anything else you want to tell me?
No.
The questioning now expands to include roommates, controlled drug sales, and who was actually responsible for the drugs found inside the house. The defendant continues offering explanations that shift from one answer to another, but the judge refuses to let any inconsistency slide. Each response only reinforces the court's belief that the full truth still hasn't been revealed. By the end of this section, the judge openly predicts that the defendant could easily return to the same lifestyle after serving his sentence.
Mr. Geigrich?
Thank you, Your Honor. I just want the court to recall that this case originated with the Lakewood Police Department Narcotics Unit, which contacted Lake County Narcotics about an individual from Menor selling drugs in Lakewood. He then conducted 3 controlled buys and did a search warrant on the home. He's talking about he's selling grams of meth for $20. Each one of these buys was for $40. It was my understanding that the charges to be reduced to take him out of mandatory prison with an agreed sentence of 2 years, which the F2 would have done. At this point, it was my understanding that we had an agreed sentence of 2 years. At this point, the defendant is indicating he does not agree to that. So I'd ask you for a 3-year sentence. Thank you.
Ms. Tomazik, do you want to address that?
Yes, thank you, Your Honor. I did have multiple conversations with Mr. Ruth prior to his plea and in the pendency of the pre-sentence report. I did reiterate to him on multiple different occasions that part of the plea agreement was the agreed 2 years. It was my understanding that Mr. Ruth did have an understanding of that. I do understand that Mr. Ruth does believe he does need treatment. I know he's gotten treatment in the past, but I know we've had multiple conversations regarding the plea agreement, Your Honor.
The questioning complete. The prosecutor summarizes how the investigation unfolded, reminding the court about the controlled drug buys and the original plea agreement. However, after hearing everything the defendant said during today's hearing, the prosecutor requests a harsher sentence than originally planned. Defense counsel explains that the defendant understood the agreement differently, But the courtroom has clearly reached a turning point where the final outcome now hangs entirely in the judge's hands.
Thank you.
Okay, I've reviewed the pre-sentence report. Consider what Mr. Ruth has said, unbelievable as it may be, what counsel has said, what their agreement that was put on the record. I don't know why you come in here and spew the nonsense that you do and expect any consideration for that. Given a very generous offer to get out of the substantial mandatory time of an F2, you have indicated to me today and in the pre-sentence report that they weren't your drugs, which is a lie. You have done your best to skirt the truth with Miss Warren and in this courtroom today. So I'm not going to go along with the agreed sentence. I'm going to sentence you to 30 months in prison with credit for 36 days that you've served, and the cost will be assessed. When you get out, you may be on post-release control for up to 2 years with the parole authority. Anything else, Mr. Geigwitz? The remaining charges are dismissed. Anything else, Mr. Geigwitz?
The forfeiture.
Forfeiture of the items. Ms. Tomaszek.
Nothing further, Your Honor. Thank you.
All rise.
The hearing reaches its conclusion as the judge delivers his final decision. He explains that the repeated contradictions and lack of honesty throughout the hearing made it impossible to trust the defendant's statements. Because of that, the judge rejects the previously agreed recommendation and imposes a longer prison sentence instead. It's a powerful reminder that credibility can influence a courtroom just as much as the evidence itself. If you enjoyed this courtroom breakdown, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss another case. Thanks for watching, and we'll see you in the next video.